bailiff has informed me that you have indicated you've reached unanimous verdicts in this case. Would your foreperson please stand for me? Yes, ma'am. Ms. Daniels, is that correct? Burkhead, I'm sorry. Juror number 8. Right. So, Ms. Burkhead, this is a yes or no question, ma'am. Is it correct that the jury has reached a unanimous verdict on each of the counts in this case?
Yes, sir.
And have you signed and dated the verdict forms?
Yes, sir.
If you would hand the entire packet to the bailiff, please. Madam Clerk, would you announce the verdict, please?
Ladies and gentlemen of the jury, your foreperson has returned a verdict in file number 17-CRS-1878, the State of North Carolina versus Wallace Bradsher. We, the jury, by unanimous verdict, find the defendant, Wallace Bradsher, in count 1 to be not guilty, count 2, guilty of obtaining property by false pretense, count 3, guilty of aiding and abetting obtaining property by false pretense, count 4, guilty of misdemeanor obstruction of justice, count 5, guilty of felonious obstruction of justice, count 6, not guilty, count 7, guilty of failure to discharge duties of office. This, the 18th day of June, 2018. Are all of these your verdicts? So say you all. Thank you.
So, ladies and gentlemen, if this is your unanimous verdict, would you, each of you raise your hand so I can get a quick head count to ensure this is unanimous? Let the record reflect that 12 jurors have raised their hand. Counsel and Mr. Bradsher, is there anything that we require of this jury with respect to these verdicts?
Yes, Your Honor. Defense will move to poll as to issue 5, felonious obstruction of justice.
All right, Madam Clerk, would you poll the jury as to issue number 5? So, ladies and gentlemen, the clerk is going to ask you a couple questions. She'll start with the foreperson, and then she'll go back to juror number 1 and move down the row. So just listen to the questions and respond accordingly. Only count 5, Mr. Bradsher?
Yes, Your Honor.
All right.
Ma'am, you as foreperson have returned a verdict in count 5 of guilty of felonious obstruction of justice. Is this your verdict?
Yes.
Do you still assent thereto?
Yes, I do.
Thank you, Ms. Burkhead. Your foreperson has returned a verdict in count 5 to guilty of felonious obstruction of justice. Is this your verdict?
Yes.
And do you still assent thereto?
Yes.
Would please stand. Your foreperson has returned a verdict in count 5 to guilty of felonious obstruction of justice. Is this your verdict? Do you still assent thereto? Yes. Thank you, ma'am. Ms. Freed, if you would please stand. Ma'am, your foreperson has returned a verdict of guilty in count 5, guilty of felonious obstruction of justice. Is this your verdict? And do you still assent thereto? Yes. Thank you, ma'am. Ms. Cox, if you would please stand. Ma'am, your foreperson has returned a verdict in count 5 to guilty of felonious obstruction of justice. Is this your verdict? Do you still assent thereto? Thank you, ma'am. Mr. Bush, if you would please stand. Sir, your foreperson has returned a verdict in count 5 to guilty of felonious obstruction of justice. Is this your verdict?
Yes.
Do you still assent thereto?
Yes.
Thank you, sir. Ms. Dawkins, if you would please stand. Ma'am, your foreperson has returned a verdict in count 5 to guilty of felonious obstruction of justice. Is this your verdict? Yes. Do you still assent thereto? Thank you, ma'am. Ms. Arneson, if you would please stand. Ma'am, your foreperson has returned a verdict in count 5 to guilty of felonious obstruction of justice. Is this your verdict?
Yes.
Do you still assent thereto?
Yes.
Thank you, ma'am. Ms. Daniels, if you would please stand. Ma'am, your foreperson has returned a verdict in count 5 to guilty of felonious obstruction of justice. Is this your verdict?
Yes.
Do you still assent thereto?
Yes.
Thank you, ma'am. Ms. Bellato, if you would please stand. Ma'am, your foreperson has returned a verdict in count 5 to guilty of felonious obstruction of justice. Is this your verdict?
Yes.
Do you still assent thereto? Thank you, ma'am. Ms. Courthill, if you would please stand. Ma'am, your foreperson has returned a verdict of guilty in count 5, guilty of felonious obstruction of justice. Is this your verdict?
Yes, it
Do you
is.
still assent thereto?
Yes.
Thank you, ma'am. And Ms. Daver, if you would please stand. Ma'am, your foreperson has returned a verdict in count 5 to guilty of felonious obstruction of justice. Is this your verdict? Do you still assent thereto? Thank you.
Anything further with respect to these verdicts, Mr. Bradsher?
No, Your Honor.
All right, Mr. Latour. All right, so ladies and gentlemen, I'm going to ask at this time that you step in the deliberation room for a moment. I'm not going to keep you much longer. It's a little bit past 5, but I'll bring you back out in a few moments. If you'll just step in there and continue to follow all the rules and instructions that I've given you. All right, the jury having returned verdicts of guilty to count 2, obtaining property by false pretenses, count 3, aiding and abetting false pretenses, count 4, misdemeanor felony obstruction of justice, count 5, felonious obstruction of justice, and count 7, failure to discharge duties of office. The jury's verdicts are accepted by the court and are ordered recorded. We have still the issue of the aggravating factor. So I'm prepared to send the jurors home tonight and resume tomorrow morning with that second phase. Has there been any discussion, Mr. Bradsher, Mr. Latour, about whether there would be a stipulation or any further discussion about that? I'm not suggesting there should be, but I just wanted to inquire of that before I...
We have not spoken about it.
That's correct, Your Honor. We have not.
All right, very good. Then we'll just have the jurors return at 9:30 tomorrow morning, and we'll begin with the second phase. I'm going to explain to them tonight what it is that we're going to be bringing them back for. I'm going to let them know. Let me find mine. I'm going to let them know that they do have an aggravating factor to consider, that an aggravating factor is not a crime in and of itself, but is a circumstance that subjects a person convicted of a crime to an increased punishment for that crime. And so I'll bring them in and explain that to them. Then I'll send them home, and we'll start tomorrow morning at 9:30. So bailiff, if you could ask the jurors to come in, you may tell them, you ask them to leave their notebooks and their notes in the jury deliberation room. They may bring their personal belongings with them when they come. All right, ladies and gentlemen, I want to thank you very much for your service in this case thus far. There is a second phase of this trial that will be required of you. And I'll just tell you at the outset, I don't anticipate that the second phase will last an inordinate amount of time. In fact, it would surprise me if it went past tomorrow, but of course we'll allow as much time as needed to resolve it. And this is a second phase of a trial where the state has alleged an aggravating factor that you must consider. An aggravating factor is not a crime in and of itself, but is a circumstance that subjects a person convicted of a crime to an increased punishment for that crime. In the second phase of the trial, you will determine, as the law requires, whether or not an aggravating factor applies to the offenses for which you have found the defendant guilty. The state must prove beyond a reasonable doubt that the aggravating factor exists, and the rules of law applicable to the first phase of the trial apply to the second phase of the trial as well. And we'll proceed in much the same fashion we did in the first phase of this trial when we address this second issue. You'll receive more instructions on that tomorrow morning, but I will need you to come back tomorrow morning at 9:30 to resume this second phase or begin the second phase of the trial. All of the rules continue to apply, and we don't talk about this case among yourselves or with anyone else. Don't express or form any opinions about this second phase of the trial. No media or independent investigation of these matters, and no conversations with parties, witnesses, or lawyers. We do want to thank you very much for being with us thus far in these proceedings, and again, we hope to use your time effectively and efficiently as we address this second phase of the trial. For those of you who brought your notepads into the courtroom and left them in your chairs earlier, if you would be so kind as to take them back into the deliberation room so that they'll be safeguarded back there and not in the courtroom. And for the rest of you, you're free to go home, and we'll see you back in the deliberation room at 9:30 tomorrow morning. Thank you all very much for your service. All right, we'll be in recess then until tomorrow morning at 9:30.